Members, we have a quorum and it is the appointed time. Item 1 on the agenda, election of deputy chairman. Prior to the meeting, the Secretariat has sent a notice notifying members that only one valid nomination was received before the deadline. That's Dr. Wendy Hung, nominated by Ms. Judy Chan and seconded by Mr. Michael Lee. According to the rules of procedures, if there is a nomination, the committee can decide whether we need to elect a deputy chairman. Now, I announce that Dr. Wendy Hung elected the chairperson of the Bills Committee on Housing Amendment Bill 2025. Now, before the administration comes in, let me say this first. I will end the meeting at 6 p.m. If necessary, we can extend the meeting by 15 minutes. Now, concerning the manner in which we consult the public, there is public hearing and written submission. Which way should we go? Public submission, thank you. Now, we will invite the administration to come in. Secretary, welcome. Now, when the administration is ready, I will first invite Ms. Winnie Ho, the Secretary, or anyone from your team to walk us through the bill. Thank you, Chairman, and thank you. My apologies. If you wish to speak, please press the request to speak button. Secretary, thank you. Now, public housing is a very important public resources. We need to allocate them to those really in need and utilize them reasonably. Since this term of government has come into office, we have passed a series of measures to crack down on abuse of public housing. The results are widely recognized. Now, between July 2022 until the end of April, we have recovered 8,000 public housing units which are subject to abuse. It is equivalent to 8 public housing estates, and we have saved 8 billion in construction cost. Now, having considered the experience gained, we have introduced the Housing Amendment Bill 2025 to propose 3 areas of amendments to crack down on abuse of public housing and make the penalty more deterrent. First, we propose to make serious tenancy abuse as an offense to prevent tenants gaining financial rewards from the public resources. So these include subletting a PRH flat or granting a license for occupation for valuable consideration and using or allowing the use of a PRH flag for the purpose of trade or businesses. Now, for those including tenants, subtenants, and licensees and sublicensees, there will be new offenses for abusing public housing resources to tally them with the offense of unlawful alienations of subsidized sale flags with a maximum penalty of $500,000 and 1 year's imprisonment. Now, second, at present, the housing ordinance does not yet empower the authorized officers from the HA to demand personal details from or demand production of identity card by trespassers or tenants and other suspected persons. Now, the bill will empower the authorized officers to demand for the production of personal details, including Hong Kong ID card. 3, the bill proposes to extend the limitation of time for prosecution of offences of false statements, refusal to furnish information, and unlawful alienations under the well-off tenants policies. Now, currently, for the related offences under the well-off tenants policies, prosecution may be brought at any time within 2 years next after the commission of the offence or within 6 months after the discovery thereof by an authorised officer. If the statutory limitation of time has expired, prosecution cannot be initiated. Now, we have discovered some tenants' household which have been found to own domestic properties and have made false declarations. However, because of the short time limits for prosecution, we cannot prosecute these households. Now, we propose to extend the time limit to within 6 years next after the commission of the offence or within 1 year after the discovery thereof by an authorised officer, whichever period expires first. And also, since the nature of serious tenancy abuse cases is the same as that of unlawful alienations of assets of subsidised sales flats, we propose to extend the limitation of time for prosecution of offence of unlawful alienations in one go to show our strong stance on abuses of public housing resources. Now, we propose that these measures be implemented by the 31st of March next year so as to allow us sufficient time to educate the public and warn tenants against any contravention. Now, to enhance the flexibility of the housing authority in managing the traffic within public housing estates, we also take this opportunity to make technical amendments to the Housing Traffic Contraventions Fixed Penalty Bylaw, Cap 283C. We propose to repeal the prescribed forms under the ordinance and instead to empower the Director of Housing to specify the forms for the relevant fixed penalty notice and demand notice and create a new schedule to prescribe the information that must be contained in the fixed penalty notice and demand notice and publish the specified forms in the Gazette. To enhance operational efficiency, alleviate the burden to both the executive and legislative authorities, and meet actual needs in a more flexible and timely manner. In January and February this year, we have consulted the committee under the Housing Authority and also the panel on housing of the LegCo. We have obtained their support. We have also incorporated the suggestions made by stakeholders. Now, besides the bill, we will continue to review our policies to adopt a multi-pronged approach to achieve the objective of rationally utilizing public housing resources. Now, I welcome members' views for enhancing our policies. Thank you. Thank you, Secretary. These are the members, Mr. Chen Hock-Fong, Mr. Ambrose Lam, Scott Leung, Kenneth Leung, Dr. Wendy Hung, and Mr. Bill Tang. Mr. Chen Hock-Fong, please. Each member has 5 minutes. Please keep to the time. And I urge the administration to be brief as well. Mr. Chen Hock-Fong. Thank you, Chairman. Concerning cracking down on serious tenancy abuse, I think there is a consensus among the public. There are outrageous cases where the tenants sublet the public housing units and make a huge profit. We want to eliminate these breaches, but there are many tenants who are worried that they may find themselves on the wrong side of the law. Many of them are grassroots people with a humble business. They are worried that they may be breaking the law simply to make a living. So will there be a clear set of guidelines to let residents understand whether they are in breach of the rules? In the process, if there are cases where there are suspected breaches of the rules, will the tenants be given a warning first to give them a chance to rectify the issue rather than initiating prosecution immediately? We don't want the tenants to be unnecessarily worried. Now, according to my understanding, only the individual in breach of the rules will be prosecuted. But what about children of the households who are not living with the tenants? They abuse the public housing resource to engage in business, but the parents who are the registered tenants will be prosecuted. So can you be targeted and flexible in initiating prosecution? I agree that we need to crack down on serious abuses, but there are cases involving misunderstanding. Can we be more flexible about these cases? Thank you. Now we are prescribing criminal offences against those who are not living in the public housing units, but they are using the public housing units for financial gain. For example, people who have emigrated but still sublet the PRH units to others. Now, for those who are not living in the units but is doing business with the PRH units, it depends on the level of nuisances caused. For those using the PRH units as a small shop, attracting a lot of footfall, we will terminate the contract and the lease. For those with minor nuisance caused, we will first issue a warning letter to remind the tenants that the behavior is against the condition on the lease. So we agree that it is very important to conduct public education. So we propose that the bill will take effect on the 31st of March next year. And in the interim, we will educate the public by using various scenarios. Now, for elderly tenants still living in the tenants, if their children is misusing the units, then first of all, the elderly couple will not be in breach of the law. And second, we would see whether the activity is solely attributable to the children.
Mr. Ambrose Lam. Chairman, I'd like to ask a similar question. Say a PRH tenant sublets the unit to another person and the secretary said it will have to look at the seriousness of the case. How do you decide, or how do you ask the property manager to decide whether it is a serious case or not? While you are going to criminalize the act, there is an exemption under the bill. And that is, if the tenant is residing in the PRH flat, he or she won't be prosecuted. What if the tenant actually sublets the flat to someone else, but the tenant still resides in the flat? Does that mean the tenant won't be prosecuted? Let me give you a suggestion. If the tenant runs a business and takes part in the business, then the tenant will be held liable. Would that work? Second question, you're going to authorize the HA officers to carry out investigations. While I'm all for this, well, police officers are usually in uniform and people won't dare refuse giving information to the police. But for HA officers, they may encounter situations where people don't cooperate. So how will you deal with such situations? Secretary, we are criminalizing the act of serious tenancy abuse. To define serious tenancy abuse, well, the tenant concerned does not reside in the flat and he uses the flat for making profit. Second scenario, the tenant does not reside in the flat and he sublets the flat to someone else. That's also a serious tenancy abuse. Other cases such as PRH tenants using the PRH flat for running a business, then that will be dealt with by the tenancy agreement. Well, people may not be able to identify an HA officer, but HA officers always carry their identification document or identification card or staff card. For PRH tenants who are hard to deal with, police officers will intervene. Mr. Scotland. Thank you, Chairman. I'd also like to ask about the definition of serious tenancy abuse and how you can let the public know whether they've committed serious tenancy abuse. Of course, you have to do more in education. Well, I think you have to let people know that after the bill takes effect, serious tenancy abuse will be a criminal act. Well, you may have people telling you that I've only lived in the flat for, say, a year or just a month. Housing officers get a lot of different excuses from PRH tenants. Especially that you are going to criminalize the act, you will get a lot of defenses and excuses from people. So how are you going to define whether the PRH tenant actually resides in the flat? Will there be a law enforcement guideline for the frontline officers? Will you be able to provide information on where you draw reference from as you, for example, come up with such a guideline? Also, when you carry out investigations, you try to collect evidence. According to the paper, a PRH tenant may use a PRH flat for business registration or run a business to sell handicrafts or make handicrafts, and this will not be considered as tenancy abuse. But in future, when officers enforce the law, will they take this into consideration? Say, for example, you get an ad or you get a business registration with a PRH unit as the address. Will you try to use this as a trace to investigate cases? Also on prosecution, I understand that you want to allow officers to have more time to work on investigations. Can you tell us how many serious tenancy abuse cases you have come across? And because of the prosecution time limit, you didn't have time to initiate prosecution. If the prosecution time limit was extended, how many of these cases would see successful prosecution? I'd like to hear from the administration about this. Secretary. For each case, it really relies on the evidence we get and the information we collect. Frontline officers, they may be able to gather different evidence. For example, they could look at the immigration record of the PRH tenant concerned, which might show that the PRH tenant is actually out of Hong Kong for a period of time. Also, as Mr. Leung said, frontline officers may come across different excuses. If it matches our definition of serious tenancy abuse, well, the case will be brought to the court, and the court will hear the evidence from both parties. Our officers will be very prudent and careful. They will collect different types of evidence, and I believe that they will be able to collect enough evidence to initiate prosecution against those who commit serious tenancy abuse. Earlier on, the Ombudsman conducted a very in-depth study on how public housing resources should be managed. The report was from 2024. It was found that some cases took place in 2020, but the prosecution time limit had already been expired. Because the prosecution time limit now is 6 months after the discovery or 2 years next after the commission of the offense. Frontline officers take time to collect different types of evidence, such as bank information, and oftentimes it takes more than 2 years. That's the prosecution time limit. Indeed, this problem has been observed by the Ombudsman too. Yes, Mr. Kenneth Leung. I'd like to follow up on the question about extending the prosecution time limit. If the administration can provide us with figures on the cases that had been missed out by the administration, I think it could better convince us on the necessity of extending the prosecution time limit. Also, a new offense will be introduced. That is, if people use their PRH flats for purposes relating to trade or business, they would commit tenancy abuse. Do you have the relevant figures showing there had been such cases in recent years? Also, you will authorize HA officers to demand personal particulars or information from PRH tenants as long as they have reasonable excuses to suspect the PRH tenants. How do you define reasonable excuses? Or, for example, an HA officer has conducted household visit for a number of times, and that the HA officer has already checked the water meters and so on, and all the information points to the HA officers that there is reasonable excuse for the authorized officer to suspect the PRH tenants concerned. So how do you define reasonably suspect? Secretary. There haven't been a lot of cases where PRH tenants leave their PRH flats idle or sublet their flats to someone else. In cases where we have to issue notices to quit, it is usually because the PRH tenants have left their PRH flats vacant, or they have used their PRH flats for storage. Well, we don't have the exact figures, but we have an appeal panel. It is an individual panel that helps us look at different cases. Members of the appeal panel would take our recommendation and then make a decision on whether the cases are substantiated. They would decide whether the PRH flat should be recovered. Over the past 3 years, 11% of the PRH tenants were recovered, and 30% of the cases, amendments were made. Amendments were made in the sense that we thought it was worth it to observe the PRH tenants' concerned behavior for, say, 3 to 6 months. Next, Dr. Wendy Hong. I support the bill. Serious tenancy abuse does not only lead to a waste of valuable resources, it would also affect the waiting time of grassroots families who need PRH tenants, who need PRH units. I have 3 questions. First, this amendment bill only applies to PRH flats managed by the HA. What about transitional housing? or subsidized housing or light public housing, will they be included in the scope? Say if I run a small business using the PRH flat, would this be against the law? I hope the Secretary could clarify, please. Say I live in this PRH flat and I run a small business using the PRH flat. Will this be against the tenancy agreement? Well, there is a low labor participation rate in Hong Kong, so we have to encourage people to take up jobs. Now, on the point about prosecution, according to Section 29A of the Housing Ordinance, the prosecution time limit now is 2 years after the commission of the offense or 6 months after the discovery of the offense. According to the Ombudsman, it takes on average 6 months to 13 months to investigate a case. I looked at the record of the appeal panel. Some cases take longer than a year to have the investigations completed. Will some cases be missed out with the prosecution time limit proposed?
Secretary, first of all, I thank Dr. Wendy Hung for supporting our proposals. On the second part of your question, that situation is related to breaching of lease condition. These are cases where the tenants are running a very small business without attracting a lot of customers. Despite still being a breach of the lease conditions, they are not classified as serious tenancy abuse activities, so they will not be caught by the bill. Now, in terms of light public housing and transitional housing, this bill mainly targets PRH managed by the Housing Authority. Now, like other systems, we have a very stringent regulatory regime to ensure that there is no abuse with the light public housing and transitional housing resources. I understand where Dr. Wendy Hung is coming from. We need to be aware of prolonged stay in these transitional housing units, which will prevent circulation. Now, in terms of appeal on prosecution, now the appeal board is now comprising of 120 members from 100 members previously, but most recently has been enlarged to 130 members. There is an increase of 30% in membership. Now, the members have been handling cases over time. Now, each appeal case takes an average of 2.3 months to complete. In the past, it was 4 months. Thank you. Next, Mr. Bill Tang. Thank you, Chairman. The government is cracking down on tenancy abuse stringently, and also there are new offenses on false information provided by tenants. So we do see the results, but there are really a lot of cases which are worthy of our compassion. Now, I have several questions. I think the previous speakers have been very gentle and mild. Now, let me give you an example. There is a neighbor of mine. There are an online influencer for advertising products. They are very famous for their work. They do this around the clock. So concerning the serious tenancy abuse activities, using or allowing the use of a PRH flags for the purposes of trade and businesses, what will the Housing Authority do? Will you just ask the tenants to report their income, or issue a warning letter and ask them to stop being an influencer. So my example is, what if I am an influencer doing advertising at home? Second, you are making the package more deterrent comprehensively. But I think we should take a carrot and stick approach. Maybe we can offer some incentives through administrative guidelines. So what about the part of carrots? I hope that the housing authority is gaining experience and is adopting a more human-centric approach to deal with breaches. So about the cases which went unnoticed or for cases where prosecution were not brought because of the expiry of the prosecution time limit, what will you do? Will you prosecute those cases after the passage of the bill? Thank you. I will defer the second question to Ms. Zhang, my colleague. Now about influencer, if you can show that you are really living in the PRH unit, if you are doing the business as an influencer and you are handing over the products outside the area of the PRH estate, then it is not a breach against the lease condition. However, if there are a lot of commodities or products in the units and you conduct the business at home, then it may be a breach of the lease condition. But it is simply a form of online working. Because of changes in society, it is very common for working from home, provided that if you are not causing a nuisance to your neighbors, it is allowed. Now, about old cases, we don't have a figure for that. Now, from the Ombudsman's report, we are made aware of the situation. That's why we reviewed whether the limitation of time for prosecution is sufficient for making prosecution. So we will not catch the old cases. Ms. Zhang? Thank you, Mr. Tang. On the 21st of March, as the meeting of the subsidized flagged units under the HA, we have reviewed the well-off tenants policy. Now, we have enhanced the regime according to our experience. There are three areas. First, PRH tenants or their household members buying a subsidized sale flagged with a white form. We will allow the tenants to remain in the PRH units until they can move to the new flagged. That's a new measure. Now, there are some cases where a household member is not aware that another household member is a property owner. For these cases, the entire household will have to be evicted, and they cannot apply for a PRH flagged in 5 years' time. Now, after the enhancement, we will allow individual reporting of income and assets. So only the one making a false report will be prosecuted. Now, the third area is there are cases where PRH tenants unwittingly became property owner because of legal technicalities, for example, inheritance or divorce. Now, after the enhancements, we will allow the tenants some time to sort out the ownership issue, and in the interim, we will not evict the tenant. Mr. Lai Tung Kwok, thank you. I have several questions. Maybe I need the second round. Now, just now, the Secretary said that one of the major proposals in the bill is to crack down on serious tenancy abuse in PRH flags. Some examples were given. However, I can't find the word serious abuse in the bill itself. So how can you justify the new offences by saying that they are serious tenancy abuse activities? Secretary, I will defer to the Deputy Secretary, Ms. Estrella Cheung. Thank you. There are many forms of tenancy abuse. As mentioned by Secretary, there are cases where the flag is simply left vacated and is used like a holiday home. And there are also cases where the tenants sublet or even run businesses with the PRH flags. So we handle these cases in different manners. Now we are introducing this bill to crack down on these abuses. This already highlights the severity of these offences. That's why we are making these activities criminal acts. My next question, Chairman. Now, Section 28A, after the amendment, under certain circumstances, it will be a criminal offence to sublet the house. Now, from the exchanges just now, besides a criminal offence, you can also evict the tenant. So there is civil action and criminal actions. So which line will you take first? Will you conduct prosecution first, or will you evict the tenants first? If you go down the criminal route, you need to gather evidence and you need to arrange for a court appearance. In the interim, the tenants will not be affected by the civil procedures until the conclusion of the criminal case. Or will you take both actions simultaneously? That would give rise to a problem, because the evidential burden or standard between criminal and civil cases are different. So which one will be your priority? I will defer the question to Ms. Estrella Cheung. Thank you, Mr. Lai. Now, the example you gave, I think for many cases, both situations apply. So for tenants who have engaged in serious tenancy abuse, we will first issue an eviction notice or notice to quit, and then prosecute the case. Of course, the evidential standard would be much higher. However, for cases which meet the bar for criminal prosecution, they would naturally meet the bar for eviction. Now, my last question. Now, for these new criminal offences, it will be the first time that the housing authority becomes responsible for conducting criminal investigation. Again, the standard for criminal investigation is much higher than those for civil investigations. Now, for colleagues, in the HA responsible for that? Do they have the sufficient training, experience, and authority to deal with that? For example, they will have to approach private banks or third parties for documentary proof. It seems that the bill does not empower the officers in HA to do these. Secretary, thank you. In our work to address tenancy abuse, we often conduct evidence gathering. For example, if a tenant claims that they have no property in Hong Kong, we will verify it. And there are cases where the court has imposed a 30-day or a couple of weeks imprisonment on the defendant. So our colleagues do have sufficient training and experience. Now, a batch of retired police officers have been employed for cracking down on tenancy abuse. So they have provided training to our HA staff in terms of statements taking and evidence gathering for secretarial purposes. So we are grateful for these retired police officers.
Mr. Michael Lee. Thank you, Chairman. Tenancy abuse is a very serious offense. Public housing is a very valuable resource, and we're in shortage of public housing, so we have to return the resources to those in need. So the government is heading to the right direction. I have the following questions. When you conduct investigations, will you make use of technology? By borrowing or subletting PRH flats, people may already be committing an offense, but there won't be any legal documents to prove that. Say, for example, they use cryptocurrencies to make transactions. You won't be able to check it or prove it. Will you make use of, for example, facial recognition technology to check what kind of people are going in and out of the PRH estates? Also, you may come across different situations. For example, people may make use of the PRH flats to hold tutorial classes, hold piano lessons, or help take care of other people's children. Before you issue a notice to quit, do you rely on the HA officers to conduct a patrol? Well, will you put in place an appeal mechanism? Will there be a central committee established with a centralized database so that all HA officers will comply with the same standards when they enforce the law? If there is a central committee or a central prosecution committee established under the housing authority, it would be fairer. Secretary. Well, Mr. Michael Lee asked about whether we will make use of technology. There are different ways to collect evidence. Different government departments may offer support to us in verifying whether a PRH flat has been left vacant for a long time. But I thank members for their suggestions. Well, last year we launched, well, actually it is this year. In January this year, we launched the Report Public Housing Abuse Award Scheme. Informants who managed to provide accurate information to us and allow us to issue a notice to quit, they'll be given a reward. We hope that through this award scheme, we'll be able to obtain valuable information so that our HA officers would be able to effectively collect evidence. We've struck a balance between having a reasonable and sensible arrangement and instituting a prosecution. As I said, we have an appeal panel to help us assess the cases to decide whether a notice to quit should be issued. Will the housing society follow the practice of the HA? We have the Housing Society Ordinance, and under the HA we have a lot of civil servants working for the HA, but for Housing Society it is different. It is not part of the government. Should we apply the same law to the Housing Society, we will have to be careful. Also, the number of flats managed by the Housing Society is about 30,000. That's 1/4 of the number of PRH flats that the HA is managing. I know that the HA, the Housing Society, has been very proactive in combating tenancy abuse. I believe that within 2 to 3 years' time, they'll be able to complete their well-off tenancy policy. Ms. Doreen Kong, I believe everyone in Hong Kong would like the government to combat tenancy abuse. I'd like the Secretary to clarify one thing. You will amend Section 22A and you will empower officers to demand personal particulars. And you'll also, in accordance with Section 25, allow HA officers to demand information about income and assets. For HOS flats without premium paid, will those be included in the scope as well? Also, if you add new occupants to the tenancy, it is currently against the law. Well, how will the Secretary educate the public and tell them that occupants will be held criminally liable if they break the law? Also, without reasonable excuse, if we assist other people in occupying or subletting a PRH flat, that would be an offense too. There are some e-platforms, and I have visited these platforms before. You can look for PRH flats for subletting. For those who run these platforms, would they breach the law? Lastly, on the rent earned by the PRH tenant, well, say it is proven that a PRH tenant has sublet the flat to somebody else. Will you have the power to recover the rent charged by the PRH flat on the subtenant? Secretary, I'll ask Ms. Zheng to address your questions about personal particulars. Well, I agree that publicity work is important, so we will have the bill take effect starting from the 31st of March next year. We will produce leaflets and we will, through letters, tell the public about the bill. There are electronic display panels in different public housing estates, and we will make use of them too. We will also make use of APIs. I'll also be interviewed by the media to help promote the bill. Now, on intermediaries, if they violate the law and they make profit by charging agent fees, they will be prosecuted. On the point about identity document, I'll ask Ms. Zheng to supplement. Ms. Kong asked whether HOS flats will be included in the scope 2. The answer is yes, according to the amended section 22A. The first part of that provision says any part of an estate's land and also land pertinent to section 22B, and that's about HOS estate. So both HOS flats as well as PRH flats will be covered under the bill. Now on declaration of income and assets, according to section 25, tenants will have to declare income and assets. Section 3A already says that the declaration will cover the PRH tenants as well as the tenants' household members. And that applies to PRH tenants, not HOS tenants. Say someone is supposed to pay more rent under the well-off tenants, but the person refuses to do so, and the income the person earns already make him a well-off tenant, then we will be able to recover, or we will have the right to recover the rent from that person. Dr. Lo Wai Kwok, public housing is an important resource in Hong Kong. It has helped settle housing problems for a lot of people in Hong Kong. We hope that people, by living in PRH flats, their living environment can be improved. We also hope to give them an opportunity to move up the housing ladder by purchasing their own flats. So if there is serious tenancy abuse, the government should definitely enforce the law strictly. I believe members of the public are all for this bill. It has been reported that the government has been taking actions against serious tenancy abuse. We have learned about this through media reports as well as reports submitted to the LegCo. I believe members of the public would support the government in stepping up its actions in this regard. However, will the government explain to the public about this bill? While there were previously successful cases where the government had combated tenancy abuse, why would we still need this bill? How would this bill fill the gap? I believe if you can explain this to the public, it would be really helpful. Secretary, I thank Dr. Lo for the questions. By committing serious tenancy abuse, a PRH tenant may not be residing in the flat, or the PRH tenant may be subletting the flat to someone else. These PRH tenants, they are taking chances. It is only when you have caught them that they would stop the criminal act. We want people to not break the law. We don't want people to take chances because if convicted, they will be liable to an imprisonment term of 1 year. I believe this bill will allow all PRH tenants to exercise self-discipline. If they realize that the PRH flats are no longer in need, they will surrender the flats to us. I understand that the existing housing ordinance is not empowering officers to take certain actions. Well, can you tell us what kind of power this bill is giving to the HA officers? All right, say a PRH tenant is not in Hong Kong. He has emigrated outside Hong Kong for a long time. Then he might want to sublet the flat to someone else by taking chances. Of course, we will do our best to find out these cases. Without this bill, PRH tenants may want to take risks. By introducing this bill, we want PRH tenants to not take chances at all and voluntarily surrender the flats to us.
So I think the message is, at present, if you chance your luck, the worst case scenario is that you have to surrender your flat. Now with the amendment, you may be sent to prison. Yes, thank you. Mr. Paul Jie. Thank you, Chairman. We support the principles of the bill, but I have some questions. First, for tenants who are staying in the flat with a little business at home. Now, when Hong Kong's economy was still poor, there were many people, including my household, which ran a small business at home. Of course, it was not something as fancy as an online influencer. We were stringing together plastic flowers and trimming the yarns on the clothing and so on. So I don't think the Secretary has experienced my hardship. Now, times have changed, I understand that, but my question is, there are activities which are now being tolerated by the authority. Now, for serious cases, warning letters would be sent. Without abatement, the tenants would be evicted. Now, there will also be criminal prosecution on top of that. So according to the paper, the tenants can appeal the orders made by the housing authority, and some 40% cases succeed. Now, what about other factors to be considered? For example, the nature of their businesses. For example, the ratio of the profits gained against the household income, and also the extent of use. Let's say if it's a 300 square feet flat, are they using a substantial percentage of the flat to make a profit? And how long do they run their business? 1 hour per day or around the clock? And also, do they cause nuisance to the neighbors by pushing trolleys full of goods? And are they causing hazards to the environment? So you need to let the tenants know what activities can be tolerated, what would warrant warnings or eviction, and even criminal prosecution. I think you need to be very clear to make the tenants understand. And also there should be a clear set of guidelines for the appeal board to consider the appeals. Secretary. Thank you, Mr. Paul Jie. That's exactly what we will do during the publicity process. We will share examples with the tenants. Now, according to the bill's design, there is a clear definition for serious tenancy abuse. For those who are not living in the PRH units and using the units to make a profit or sublet the units, these are serious TA activities. The situations mentioned by Mr. Paul Jie are actually breaches of lease conditions. It depends on the extent and severity of the breach. There are mild, minor, and infrequent breach of conditions. For these situations, we will only issue a warning letter. However, for serious abuses and constant nuisance, for example, using the PRH units essentially as a mahjong parlor, for these cases where serious nuisances are caused, we will immediately evict the tenants and prosecute the case. The job of the appeal board is to consider the merit of each and every case, and also the nature of the business, the frequency of nuisance, and the severity of the abuse. So these are the factors to be considered by the appeal board. A technical question here. Now, the prosecution's time bar or limitation of time for prosecution is extended from within 2 years to 6 years next after the commission and to 1 year after the discovery of the offense. Now, what about cases which have been discovered before the passage of the bill and is continuing? When will the starting point of the limitation of time for prosecution be? Thank you for your question. There is another question about that, which I did not answer just now. Now, this bill has no retrospective effect. For offenses which took place in the past, they will follow the old rules. Now, the proposed change is that the limitation of time for prosecution will be extended from within 2 years next after the commission of the offense or within 6 months after the discovery to within 6 years next after the commission of the offense or within 1 year after the discovery of the offense. But in any event, there is no retrospective effect. Sorry, just a brief clarification. I'm not asking about the retrospective effect. For cases discovered before the passage of the bill, will the time of the discovery be so that render prosecution impossible? Mr. Young, please. That depends on the time of commission of the offense, whether it is before or after the passage of the bill. For those which were committed before the passage of the bill, the old limitation of time for prosecution will apply. Mr. Scott Leung. Thank you, Chairman. Now, Mr. Lai Tong Kwok asked a question about the eviction notice and also the criminal prosecution. Which one will be the priority? Now, according to the Deputy Secretary, if a case is so serious that it warrants criminal prosecution, then it would naturally qualify for eviction. Now, for criminal offense, before conviction, in theory, the defendants can claim that they are innocent of any crime. Now, let me give you a very extreme scenario. In the end, if the court, for whatever reason, acquitted the defendant, then can the evicted tenant appeal the case to the appeal board and have the tenancy status reinstated? Because there is always the likelihood that the court would acquit the defendant. Secretary, I will defer to Ms. Estrella Chung. Thank you, Mr. Leung. There are two sides of this. Now, the situation I mentioned was a prima facie case of serious abuse. For these cases, we would believe that the lease conditions have also been breached, so we would issue an eviction notice on that basis. So that would have dealt with the situation of tenancy abuse warranting eviction. In terms of criminal liability, the bar is much higher than that of an eviction. That decision would be made by the court. If the court acquits, even if the court acquits the defendants of any criminal liability, it doesn't mean that there is no civil liability to be borne by the tenants, and that would have been dealt with by the appeal board. So my question is whether the tenants would use the acquittal as a ground for appeal to the appeal board. Would they make use of this ground and have their status reinstated, secretary or deputy secretary? There are two distinct systems for dealing with these two scenarios with very different standards. So I think we can resort to each of these mechanisms to deal with these cases. Mr. Chen Hock-Fung. Thank you, Chairman. I had two questions, but one of them has been answered. That there is no retrospective effects to the bill. That's clear. Second, the Director of Housing can specify the form after the amendments. I understand this is for convenience. It's not convenient if you have to come to the Legislative for our approval every time you change the form. But will the Director of Housing have the power to amend the fine level? That would be a whole different matter. Ms. Zhang? Thank you, Mr. Chen. Now, this proposal is only about the power to amend the form. Now, subsidiary or bylaw C, it stipulates that the fine level would be in line with the traffic contraventions fixed penalty by law. So for the form, will the, or rather the fine, how can the director change the amount? So for the form, you don't have to approach the Legislative anymore. The director can specify the form. In the past, the director has to obtain an approval from the Legislative to amend the form. Yes, that's just about the format of the form. The amount of the fine is not specified through that by law. According to other ordinances, we have to follow the amount set by the Director of Transport. Mr. Lai Tong-Kwok, thank you. If a person sublets the PRH flat without authority, then does the administration have the power to confiscate or claw back the financial gain arising from this unlawful activity? If so, it would be much more deterrent. Now, let's say if there is a provision saying that upon conviction by the court has the power to convict the financial gains arising from the illegal act, that would be very powerful. It will also have an impact on those assisting the unlawful behavior, including the intermediaries and the agencies. Second, about small businesses. In the bill, there is an exemption. That is, if at the time when the flat is so used, a tenant under an authorized lease in respect of the flat or another member of the tenant's household is residing in the flat. But what does it mean by is residing? What's your policy intent behind this? Now, during the clause-by-clause stage, I will also raise this question. This is an excluded situation under this criminal offense. So how do you define is residing? How many days do the tenants have to reside in the flat? It may give rise to a legal challenge. Whether the tenants are criminally liable depends on whether they are residing in the flat, and that depends on how many days they are living in the flat. So maybe we can discuss that further during the clause-by-clause stage, whether we need to further refine the wording. Thank you. Secretary. Chairman, I thank Mr. Lai for his questions. Now, when an abuse is discovered, for serious tenancy abuse, the maximum penalty is $500,000 in fine and 1 year's imprisonment. Now, these maximum penalties are very serious, and they are proportional to the offense. So we don't think we will consider the financial gains earned and claw back the gains. Now, for tenants who are now considered well-off tenants, we can recover the differences in rent levels. Now, on whether the escape clause applies, a tenant must be residing in the flat. Now, say for example, a tenant works night shifts, then we will ask for the employment record to show that the tenants are not residing in the flats, sometimes because of the night shift work. But that would not affect the definition of continuously residing in the flat.
Chairman, I don't intend to carry on with this discussion at this point. I see that there could be different complex situations. In exemption cases, the evidential proof, the burden of proof lie on the defendant. According to the bill, if the case is brought to the court, it will be up to the prosecutor. Or it would be up to the defendant to prove that he is innocent. Mr. Paul Che, I agree with Mr. Lai Tong Kwok. In cases involving gambling establishments, if you use habitual use, it could be a defense. How do you define whether a PRH tenant is residing in the flat? Do you have to prove that the PRH tenant is habitually residing in the flat? Or is it that when you spot the case, you have to prove that at that moment the PRH tenant is residing in the flat? I think you have to be clear about this, and we'll have to study if the terms used in the bill are clear enough. Now I want to follow up on the point about prosecution time limit. If within 6 months' time before the bill takes effect, an HA officer spots a serious tenancy abuse case, and the case is not prosecuted within 6 months after the bill takes effect, will the case no longer be prosecuted because of the existing prosecution time limit? What I'm saying is that what if you have already spotted certain cases before the bill takes effect? Will that shorten the prosecution time limit? The existing time limit is 6 months after the discovery and 2 years after the commission of the offense. What if the case is spotted before the bill takes effect, and after the bill takes effect, the prosecution time limit already expires? Who will take the question? Secretary. I will address the first part of the questions and I'll ask Ms. Chen to supplement. I thank Mr. Paul Che for raising the point about residing in the flat on a continuous basis. There were cases where the PRH tenants no longer reside in the PRH flat and they've turned the PRH flat into a gym. And there have been advertisements about the gym, and these are clear evidence. Say, some people may have turned a PRH flat into an Airbnb apartment, and we can find a certain evidence online. There are also cases where the tenant's employer asks the tenant not to reside in the PRH flat for a certain period of time. In such cases, we'll have to ask for the proof to see whether the employer is asking the tenant to do so by asking for the payroll slip or the employment contract, for example. Will you come up with certain scenarios before the bill takes effect? I think it can easily be decided whether a PRH flat is residing in the flat by looking at, for example, whether there are any personal belongings in the flat. Is there just a bed, for example? Are there any clothes? Say if there's nothing in the bathroom, and this could be an evidence showing that the PRH tenant is not residing in the flat, and these are some usual evidences provided by the HA officers to our appeal panel when we submit cases to the panel for assessment. For example, we can collect photos online and they could become part of the evidence. Also, we have employed some retired frontline police officers and they could help us decide what kind of evidences would be favorable for us. For the other parts, I'll ask Ms. Chen to supplement. Under Section 29A, we have introduced a new Part 3. It says that any criminal offenses committed before the 31st of March 2026, the existing prosecution time limit will apply. That's 2 years or 6 months. Any offenses committed after the 31st of March 2026, the new prosecution time limit will apply. Mr. Lai Tong-kwok. Chairman, I'd like to follow up on Mr. Paul Che's questions. Are these offenses continuous offenses? Some offenses may be committed before the bill takes effect and others may take place after the bill takes effect. If it is not a continuing offense, then what Ms. Chen said would apply. Let's say if it is a continuous offense, that means the PRH tenant keeps committing the offense, then the situation would be different. Say a person has stolen something, and the offense is committed when the stolen act is committed. But keeping a stolen property, it is a different story because it is a continuous act. Ms. Chen, please. I thank Mr. Lai for the comment. For continuing offenses, well, as long as they are committed or still being committed after the 31st of March next year, then we will make use of the new prosecution time limit. This is because the act is still being committed after the bill takes effect. This is my understanding of the bill. Well, we have already discussed the pros and cons of the new system. Let's see if there are further questions from members. Yes, Mr. Poche. Sorry, Chairman. My brain is running slow as the Easter holiday is around the corner. We understand that the cutoff date will start on the 31st of March 2026. Say, before the 31st of March next year, the HA already notices a tenancy abuse case. If the case straddles across a date before the 31st of March and a date after, then how will the government deal with such situation? Understand what the existing policy is. But will the bill clearly shows us that only offences committed after the 31st of March will count? Ms. Chen? 6 months after the discovery of a tenancy abuse case by an HA officer is the current prosecution time limit. If an offence is committed after the 31st of March next year, then we have 1 year after the discovery to prosecute the offender. Say it is a continuing offence that spans across a date before the 31st of March and after the 31st of March, then the 2 years plus 6 month prosecution time limit will apply. And the time will be counted starting from the discovery, not the 31st of March. Anything to add by the DOJ? For offences committed before the bill takes effect, it is only if it constitutes an offence that the offence would be prosecuted. There is only one date when one can spot a case. So the prosecution time limit will be 6 months after the discovery. Say an offence is not discovered, then the prosecution time limit will be 2 years after the commission. Say there are offences committed before the bill takes effect, the existing prosecution time limit will apply. Say there are offences committed after or on the 31st of March. For offences under Section 28A, there are new offences, so there's no way that these offences could be committed before the bill takes effect. And for these new offences, the longer prosecution time limit will apply. I don't want to make any implications. I'm just giving an example here. For the 47 people case, some new offenses were added, including conspiracy, which make the case more complicated. Understand that serious tenancy abuse cases aren't so complicated, but if you use the date where the case is discovered, it could be complicated. Well, I'll think about it during the Easter holiday. Well, we will also look at whether there are things that need to be refined during the Easter holiday. Well, I guess we can now move on to the clause-by-clause scrutiny. Members, please refer to the marked-up copy of the bill. I suggest that we use the Chinese version of the marked-up copy, and the legal advisor will look at the English copy. Please walk us through the bill. Thank you, Chairman. Page 1 of the Chinese version. The amendment is concerning Section 16. If members have any questions, please press the Request to Speak button anytime. Let's also look at the bill C2200. It is the long title. There are 5 purposes. The first is to criminalize the unauthorized letting, occupation, or use for trade or business of rental residential flats of the HA's estates. The second goal is to empower authorized officers to require persons believed to be trespassers or to contravene the ordinance to furnish identity information. The third goal is to extend an offense for the refusal to furnish information to cover the refusal by estate tenants or members of their households to furnish information regarding their total income and assets. The fourth goal is to extend the limitation of time for prosecuting an offense relating to unlawful alienations of land. The fifth goal is to empower the Director of Housing to specify certain forms of notices for the payment and recovery of fixed penalties.
Mr. Lai? Thank you, Chairman. Now about the long title. It starts off by saying business or trade. Now, there are no definitions for these two terms in the bill. I wonder if I should raise the issue here or down the road when we come to trade or business. Administration. Yes, when we come to Section 28A, we will explain the terms. Thank you. Second question, line 3. Require persons believed to be trespassers. I understand the English text, but why do you say some or yase in Chinese? If the authorized officers believe someone to be trespassers, that would suffice. Now, in the same sentence, trespassers believed to have contravened the ordinance. In Chinese, it says 該條例. It seems that you are referring to another piece of ordinance, but not this one. So that's a drafting issue. Sometimes I think the Chinese texts are just so-so. They are not very accurate. Thank you, Chairman. About the Chinese term 該條例, the ordinance. Now we start off by saying the housing ordinance. So that refers to that ordinance. So this Housing Amendments Bill 2025, it is now a bill. Upon passage, it will become an amendments ordinance. So this is also a piece of ordinance. So the ordinance means the principal ordinance. Now, 該條例, meaning the ordinance, refers to the amended ordinance. Understood. Please continue. What about the term some, yase? Yes, for the Chinese text of some, yase, we believe the Chinese text and the English text are aligned. Now, in English, we says require persons believed to be trespassers or to contravene the ordinance. So that's why we think in the Chinese text we should use the plural form of trespassers. Another question, Chairman. The third line from the bottom. Specified certain forms of notices for the payment and recovery of fixed penalties for the contravention of bylaws relating to vehicles within the estates. Payments of fixed penalties is an action. So upon receipt of the notice, one has to pay the fine to discharge the criminal liability. But I don't think the Chinese text is very consistent. I think the English is okay, but the Chinese text should be improved. DOJ. Thank you, Chairman. Now the Chinese words 用于. Now the whole sentence is to empower the Director of Housing to specify certain forms of notices. And then we want to specify what notices are these. So one, they are the payment notice of fixed penalties for the contravention of bylaws. That is fixed penalty notice. The other kind is a notice for recovery of fixed penalties. That is the so-called demand notice. We want to describe the notices in details in the long title. So by simply using the terms fixed penalty notice and demand notice, one may not understand the purposes of these notices. So we are trying to describe the uses of these notices in full. Dr. Lo Wai-kwok. I find this quite peculiar to require persons believed to be trespassers or to contravene the ordinance. The Chinese words 一些 is problematic. Deleting the Chinese words 一些 meaning some will not affect the meaning of the sentence. So usually in Chinese, we don't have to specify whether a term is plural or singular. If you go further down the passage, the term vehicles, why do you not say 一些 vehicles or some vehicles in the Chinese text? So I don't think your rationale is valid. If that's the case, you need to add the word 一些 in front of 車輛, meaning more than one vehicle. So according to my experience, I don't think I've seen any bill like that. DOJ. Thank you, Chairman, and thank you, Dr. Lo, for your observation. Now, when we refer to person in Chinese, 人, in Chinese, there is not a clear distinction between plural or singular terms. So there are two verbs in this sentence, require and believed to be. So it may give rise to misunderstanding. For example, one may construe it as believed to require persons who are trespassers. So that's why we are trying to break it apart and make the meaning clearer. Now, again, if you delete the Chinese word 一些 or some, it would not affect the meaning. It simply means require a person believed to be trespasser or to contravene the ordinance to furnish identity information. There is no room for misunderstanding. Now, simply because there are two occasions where the Chinese word believed, 相信, appear in the sentence, you are making it more clumsy. So I don't think you can justify your decision. Now, we do come across these situations from time to time in a Bills Committee setting. Now, reader friendliness is different from the legal point of view. Now, you can get your point. You have got the point across. Chairman, you are I think you are working against me. Anyway, I will invite the DOJ to consider the members' views. And please tell us what you think after today's meeting. Mr. Michael Lee. Yes, I fully agree with Dr. Lo Wai-kwok. Now, in the English version, there is the term person is in the plural form. So what about an individual? What about singular? Because you have used the plural form of person in the text. What about if there is only one person? Can you still require a single individual to furnish their personal details? Maybe it would be better to use a quotation mark to signify the differences. Then it would be very clear that you can require these two types of persons to furnish their personal details. Just use the punctuation marks. Yes, please consider their suggestions. Mr. Porter, actually, we are quite used to this kind of clumsiness. One usually has to refer back to the English version to understand what it truly means. Anyway, what is your rationale for using the word 者 in Chinese and 人 in Chinese? Why don't you simply use person, 人, on both occasions? DOJ, thank you, Chairman. In response to members' questions, both means persons. It just depends on the flow of the sentence. Now, trespasser is very common. It's commonly translated as 侵入者 in Chinese. So we think this is the appropriate translation. If you use a person who trespasses, it simply means the same. What about someone who contravenes the ordinance? Now, for that part of the sentence, we think a person who contravenes the ordinance or 違反該條例的人 in Chinese is clearer. Can we invite Ms. Sherry Young, Assistant Director, to supplement? Now, we have referred to Section 21 of the ordinance. In that section, we have used the wording 侵入者, so that's why we are aligning the bill with that part of the ordinance. Now, it depends on the policy intent of the bill, whether we would only serve the notice on more than one person, or actually, if you refer to the ordinance, the singular form of person also exists. Considering whether we will change the Chinese text, we will study members' suggestion. Ms. Judy Chan. I'm also reading the Chinese text. It goes, require persons believed to be trespassers or to contravene the ordinance. Well, believed to be, can we just say suspected to be? Would that be clearer? Believed to be and suspected to be basically mean the same thing from a legal point of view. Yes, please study the member suggestion. Yes, please continue. Next, C2203 of the Blue Bill, Preliminary, Part 1. 1. Short title and commencements. 1. The ordinance may be cited as the Housing Amendment Ordinance 2025. Subclauses 2 and 3, commencement dates. Subject to subsection 3, this ordinance comes into operation on the day on which it is published in the Gazette. No, it relates to fixed penalty notice and demand notice. So for these clauses, they will come into effect on the day of Gazette. Now for sections 3 to 10, they relate to the offences in relation to serious tenancy abuse and power to require furnishing of identity card, they will come into effect on the 31st of March next year. Are you referring to the markup copy? No, the blue bill. Would you use the markup copy? Now, the first page of the markup version does not have this part on the bill, so we have to refer to the blue bill. Do we all have the blue bill? Mr. Portier, Chairman. I know the Chairman is very hardworking, but actually the agenda says we will finish at 5 p.m. I've extended the meeting to 6. Did you? Yes, I said that right from the start. Yes, since we can't finish it today anyway, why don't we just follow the original time? Well, I think we still have some time, so we will continue anyway. Yes, Chairman. Secretary. Now we suggest the administration use the markup version to scrutinize the bill. Besides the long title, we can use the markup copy. It would be easier. Now the commencement days are not on the markup version as well, so we have to use the bill for this part. Yes, that starts from clause 16. So let's go back to page C2203 on the blue bill, short title and commencement. Now the ALA has sent us a letter before the meeting asking why there are 2 commencement days. And there are concerns about the publicity and education efforts of the administration, and that there should be sufficient training for the frontline officers to enhance enforcement. That's why for criminal liabilities, those will come into effect on Gazette, while the other parts of the bill will come into effect on the 31st of March. Now, page 1 on the markup copy. Section 16C, it is a minor technical issue, only involving the Chinese text to make the text more accurate. Now the term subletting lease occupying any part of the land, we will delete it in the Chinese version because it refers to the permits only, but not the lease. So to make the Chinese text more accurate, we propose to amend the Chinese text to align the Chinese text with the English text. That is, lease, sublease in relation to occupying any part of the land.
Yes, please proceed. Page 2 of the Chinese version. Under Section 22, we are introducing Section 22A, power to require identification. There are 4 subclauses. The first subclause is about the right. 1A, any land in an estate let for residential purposes, and B, any land mentioned in Section 22B that subsidized sale flats. 2, it talks about under what scenarios we could invoke this power. For performing a function under Section 21, an authorized officer may exercise the power specified in subsection 4 if the officer has reasonable grounds to believe that a person to whom this section applies is a trespasser in an estate. Subclause 3, an authorized officer may exercise the power specified in subsection 4 if, in conducting an inspection, the officer has reasonable grounds to believe that a person to whom this section applies has contravened Mr. Lai Tung Kwok has a question. Subsection 2, the term trespasser is used. Say an authorized officer has reasons to believe that someone is a trespasser, then the officer may exercise the power to demand identity documents. But this subsection does not specify what kind of persons will fall under the definition of trespassers. You say here that a person may be asked for identity document, but you aren't providing a definition for trespasser, so this might not be clear enough. Do you think there is a need for you to enhance clarity to avoid any legal disputes in future? If the person concerned does not listen to the officer, it could be a criminal offense. Anything to reply? Section 21 introduces the concept of trespassers. If a person is not authorized to live in the estate concerned, then the person may be regarded as a trespasser. Chairman, I know that the existing ordinance covers the term trespasser, but it is not a criminal act. Now that you're criminalizing the act, I think you should make the provisions more precise. So I'm wondering if you think it's necessary to enhance the clarity here. Ms. Doreen Kong, yes, riding on what Mr. Lai said, I'm thinking if we do not define clearly the term trespasser, there might be gray area. How can we define who is a trespasser and who is a visitor? Also, I'm reading subsection 3 here. How would the authorized officer know that the person would contravene or is contravening this ordinance? Could you give us some examples, please? It may involve Section 28A. It is a new section about serious tenancy abuse. If it is suspected that the tenant is subletting the PRH flat concerned and that someone is renting the apartment, then this would be considered as a contravention of the ordinance. I'd like to add one point about the definition of trespasser. According to the new Section 22A, an officer can only demand a person to provide identity document if the person is inside the PRH flat concerned. This is in the first line. If the person concerned is, say, in the corridor, then the officer would not be able to ask for identity document from the person. Of course, the person will have to be on the land concerned in order for the person to be considered as a trespasser. So it doesn't matter whether the person is on the land concerned or not. The problem is how you define the person on the land as a trespasser. Like Ms. Doreen Kong said, there isn't a clear definition for the term trespasser because we're talking about a criminal offense here. If the person refuses to cooperate, then the person would be considered to have committed a criminal offense. That's why I'm asking if there is a need for you to clarify this. Let me give you an example to illustrate this. Say the tenant is a man, but during our household visit, we see a woman in the PRH flat, and the woman is, say, for example, throwing garbage, then the woman may not be a visitor. Then we will check whether the woman is illegally residing in the flat. Does it answer your question, Mr. Lai? If the person is authorized to enter the flat, then the person would not be a trespasser. If the person does not agree with the officer and lodges a complaint for ultravirus, then it will give you a lot of trouble. The complainant may take the case to the court. Of course, you can come up with certain administrative procedures, but what I'm saying is by enhancing the clarity, it could save you a lot of trouble. If you can deal with the matter in the proper way, then you can ensure smooth law enforcement. Well, I believe Mr. Lai is speaking from his own experience as he was serving as a Secretary for Security for many years. Yes, Dr. Lo Wai Kwok. I don't think disputes will arise because the officer is only asking the person concerned to provide identity document. Say the person says she is the cousin of the PRH tenant and she is only helping to throw away the garbage, then there will be no need for the officer to follow up on the case. So perhaps you can come up with some guidelines to avoid all these potential disputes. Yes, please carry on. Now, subsection 4 is about what kind of information the authorized officer could ask for. They include A, the person's name, address, and contact phone number, and B, proof of identity. Yes, Mr. Lai Tong Kwok. Thank you, Chairman. Subsection 4 here. I have a question. I wish the administration to clarify this. Subsection 4b says to produce for the officer's inspection the person's proof of identity. The proof of identity is to verify the officer's identity or the person concerned's identity. Secondly, in English you said require the person. Does that imply a verbal instruction? If not, then the person could demand the authorized officer to provide a written instruction instead. So please clarify, what does to require mean? The proof of identity is to show that the authorized officers is authorized to carry out the inspection. Now, on the term requiring, it implies a verbal instruction. Which page are you referring to? We've just finished subsection 4 under section 22A on page 2. Now, page 3 of the Chinese copy. We are adding 3A, subsection A and B under subsection 3. Subsection 4 applies to a person who is A, a tenant of any land in an estate, or B, another member of the tenant's household. Section 25, subsection 4. A tenant of any land in an estate will be amended to person to whom this subsection applies. Also, regarding his total household income or his total household income and assets will be amended to the person's income or the person's household income and assets. So instead of requiring just the tenant to provide the household income and assets, we are asking the tenant and the household members to provide the income and assets.
Dr. Lo Wai Kwok. Chairman, household members, do we need to specify whether it is a household member who is residing in the flat? So the person may be a family member not living in the same flat. Should we define the term more clearly? Now, household member, under Section 2 interpretation of the Housing Ordinance, for the purpose of tenants, it means persons whose names are also on the lease. So household members you are referring to doesn't just mean just any member of the household, but members whose names are on the lease as well. So if the definition exists in another section, that would be fine. Otherwise, it would be very vague, because what if my cousin visits me? Do I have to declare it as well? Now, Cap 283, Section 2, the Housing Ordinance, the definition already exists. That's fine, but can you refer me to that definition? Because I think this is very important. Please, Deputy Secretary, not just for me, for everyone's benefits, we will supplement the information to the Secretariat after the meeting. Which documents, please? So maybe you have to supplement the information to us that there is already a definition for household members. Otherwise, you may have the power to require information from any household members who visit my flat. Mr. Rin Kong. Thank you. Now, subsection 3A, it only applies to PRH housing. That's fine. But according to 3A, it says a tenant of any land in an estate. It can be construed as a tenant of a subsidized sales flat with premium paid. I've studied the definition for tenants in Section 2. Thank you, Mr. Rin Kong. Your understanding is correct. That's 25 brackets 2. If we are invoking Section 25 brackets 2 to require information, Chairman, I'm not talking about subsection 2. I'm talking about subsection 3A. Now, the administration said that the new amendment to Section 25 will not affect subsidized sales flags or HOS. But when I refer to subsection 25(3)(a), it says a tenant of any land in an estate. The scope is very wide. It will also include tenants in HOS flags with premium paid. So if you refer to the definition of a housing estate, in the definition, it says a land controlled by the housing authority and managed by the housing authority according to the covenant of mutual deeds. But that's DMC. If there is a DMC, it is not a HOS estate. What about the Shui War estate? Well, it says land owned by the housing authority. If it is a HOS flat, the ownership is not with the housing authority. So please study my suggestion. If it is referring to the PRH estate, then the issue of DMC will not exist. I'm just asking you to consider this part. Now, the legal advisor asked a question about this as well. In the legal advisor's letter, there is a question whether there is a specified form for reporting total income and access. That's true. We have this specified form. And whether there would be a set of guidelines defining what counts as income and access. Again, we do have the guideline for these for reporting income and access. And whether we need to amend the relevant ordinance under Cap 283, that's not necessary. That's about charging additional rent for well-off tenants, and we have specified that it would be counted based on the total income of the household. Any further question from the legal advisor? Please continue. Now, page 4 of the markup copy. There is no amendment, but that's involving Section 26B. We propose to add subsection 26C, failure to produce proof of identity for inspection, and etc. A person who, without reasonable excuse, fails to comply with a requirement made under Section 22A4 commits an offence and is liable on conviction to a fine as level 3 and to imprisonment for 6 months. Please continue. Now, responding to the legal advisor's question, the burden of evidence, the burden of proof. Now, this is the evidential burden. Now, the details are set out in Section 29B. Any further questions from the legal advisor? Now, page 6 of the markup copy. Amending Section 27, refusal to furnish information. Subsection A, a minor amendment. To produce his lease or. And subsection C, refuses or neglects to furnish any of the particulars specified in a requisition under Section 25(4). So that's the additional subsection C. Thank you. Next, page 7 of the markup copy. After Section 28, we will add 28A. It's about the offences for serious tenancy abuse. Now, subsection 1A, it specifies who would be caught under the bill. Now, it means a person who lets or agrees or offers to let a rental residential flat to another person. B, occupies or agrees to occupy a rental residential flat let by another person. Or C, otherwise uses or allows the use by another person of a rental residential flat for purposes relating to trade or business, then the person will be committing an offense. Now, I also refer you to subsection 2 on trade or business. There are some exclusions. That includes 2A, that is, subsection 1C does not apply if A, the use is permitted under an authorized lease, or B, at the time when the flag is used as described in that subsection, a tenant or another member of the tenant's household is residing in the flag. Subsection 3, a person who without reasonable excuse assists another person in doing an act mentioned in subsection 1A or B for valuable consideration commits an offense. Ms. Doreen Kong. Chairman, just very briefly. Section 28A, 1C. For purposes relating to trade or business, this is very wide. I will not repeat the other members' concern, but please consider this. According to the ILD's cases, what constitutes trade or business is a point of issue, of contest. According to the ILD, it is the carrying on of a trade or business. Now, for the ILD cases, on what constitutes carrying on a trade or business, there is a clear definition. Now, we're not using the term carrying on. We're just saying, for purposes relating to trade or business, there is a chance that this is more wide-catching than carrying on of trade or business. So please refer to the ILD's precedences. Yes, please. Please continue. Page 8 of the markup copy. Subsection 4, a person who commits an offense under subsection 1 of 3 is liable on conviction to a fine of $500,000 and to imprisonment for 1 year. Subsection 5, in this section, a reference to letting a rental residential flat to a person. A is a reference to letting or subletting for valuable consideration the flat to the person. B includes granting, for valuable consideration, a license or sublicense to the person for occupation of the flags, and C does not include letting or subletting the flags or granting a license or sublicense for occupation of the flags under an authorized lease. And subsection 6, in this section, there are some terms including authorized lease, rental residential flags, and valuable consideration. So there are interpretation for these terms. Now, since the members who have quite a lot of questions are no longer here, so how about we stop here and resume next time? It's okay if you say no. I'm okay to continue. That's great. Let's continue. I'm just worried that people would say that we are rushing through the bill. So let's continue. Dr. Lo Wai-Kwok. Now, my only consideration is that many members have left. Dr. Lo Wai-Kwok. Now, my view is just that we should continue. Those who have views should have stayed. Yes, I think those members can even submit the questions in written form. Their views will also be considered. Ms. Doreen Kong, just very briefly. Now, there is a reference on page 7 about rental residential flats and authorized lease. Now, it says it means a lease granted under section 16 brackets 1. That's very clear. So that refers to a flat rented out by the housing authority. Now, I said that 23(3)(a) was not clear. If there can be a provision saying that the term refers to a lease granted under section 16(1), that would be very clear. Yes, we will consider that suggestion. Now, page 8, we have gone through page 8. Now, page 9, section 29A, limitation of time for prosecution of offences. Now, after subsection 1A, we propose adding section 27C, 27A, or 27 or 28A brackets 1 or 3 after the existing sections. Now, these are sections with shorter limitation of time for prosecution. Now, the point is to extend the time of prosecution of offences. So, concerning serious abuse of tenancy and assisting serious tenancy abuse and also unlawful subletting, these would apply. Mr. Ring Kong. Sorry, that's a mistake. Now, subsection 1B, for offences with a longer limitation of time for prosecution. Again, we want to include those offences with a longer limitation of time for prosecution. Now, we will repeal the original subsection 2. That was just a transitional provision before the amendment. Now, we will add subsection 3. It specifies the new limitation of time for prosecution. So it says this section as in force immediately before the 31st of March 2026 applies to an offence committed before that day as if the relevant amendments have not been enacted. In other words, when the offences were not in place when the law comes into effect, they will not apply. For those with an offence, for those which the offences already exist, the original time limitation will apply.
We are introducing section 29B, reasonable excuse. It is to explain the relevant provisions. There are subsections 1, 2, and 3. They talk about what constitutes a reasonable excuse. Under certain circumstances, say a person can prove that there is a reasonable excuse for his act if there is sufficient evidence and that the person can raise an issue that would be a reasonable excuse also if the contrary is not proved by the prosecution beyond reasonable doubt, a person is considered to have a reasonable excuse, so it is an evidential burden of proof. Now for section 30. We propose repealing subsection 3 and introduce a new subsection 3 with bracket A and bracket B. Bracket A, a fixed penalty or an additional penalty to be payable in discharge of any liability for contravention of bylaws made under subsection 1G or GA, and bracket B, the payment and recovery of the fixed penalty or additional penalty. We propose adding subsections 4 and 5. Subsection 4, a provision of bylaws made in reliance on subsection 3B may empower the Director of Housing to specify by notice published in the Gazette, not being subsidiary legislation, the form of any notice for the payment or recovery of the fixed penalty or additional penalty. Subsection 5. Subsection 4 does not prevent the bylaws from imposing any requirement on the content of a penalty notice. Yes, Dr. Lo Wai Kwok. I'd like to seek clarification on this. Say the government would like to revise, say enhance the penalty amount. How would the government deal with it? It's not specified here. Here, only the form of the notices is mentioned. What if the penalty amount is to be revised? As mentioned, Regulation 6 of Chapter 230C stipulates that the penalty amount will be the same as that set under the Fixed Penalty Traffic Contraventions Regulations. The fixed penalty notice as well as the demand notice will be published in the form of a gazette, and we will publish a new notice if there is a change in the penalty amount. So the director won't change the penalty amount. So you will follow the traffic contraventions regulations, right? Yes. Page 12 of the Chinese copy, interpretation. Here we propose adding definitions for demand notice and fixed penalty notice. Next page is about fixed penalty notices and demand notices. We want to simplify the provisions. We want to change Form 1 into fixed penalty notice. So all these amendments concern the same thing. Yes, please carry on. Before subsection 3, we propose adding subsection 2A. It states that a fixed penalty notice must be in the form specified and must specify the manner in which the fixed penalty may be paid and contain the information set out in Part 1 of Schedule 4. Yes, please continue. For subsection 3, we proposed repealing Form 2 in Schedule 3. Form 2 in Schedule 3 will be deleted, so we will delete the relevant wordings. In subsection 4, we propose deleting the part "no notice shall be served" under that subsection and change that into "demand notice may be served." We also propose repealing the original subsection 5. The relevant provision has been moved to subsection 7A. For subsection 6, the part "a notice" under subsection 3 will be changed to "demand notice." These are all technical amendments. Page 14 of the Chinese copy. We propose amending the original subsection 7 to state that a demand notice must be in the form specified, must specify the manner in which the fixed penalty may be paid, and must contain the information set out in Part 2 of Schedule 4. The original subsection 5 has now become subsection 7A. Also, we are adding subsection 7B stating that a notice published is not subsidiary legislation. For subsection 8, we're amending the part "the notice" under subsection 3 into "demand notice." Yes, please carry on. Page 15 of the Chinese copy. About payment of fixed penalty. Here, we propose simplifying the statement in subsection 1 by changing the part into "fixed penalty notice or demand notice may, in accordance with the notice, pay the fixed penalty within the period of time stated in the notice." For subsection 2, we're introducing a technical amendment. We're going to change subsection 1A or B into subsection 1. I understand why may was used in subsection 9.1 because different payment methods were proposed. But in the latest amended version, it is a much simplified version. Without the payment options, should we still use the word may? We are not including the payment options in this bill, but in the notice published in the Gazette, we will clearly set out all the possible payment methods. I thank Ms. Doreen Kong for the questions. The ALA also asked a similar question, and our reply is the same. Page 16 of the Chinese copy. We propose repealing subsection 6. And for subsection 7, we are amending the part the notice served under section 8 bracket 3 into demand notice. It's a technical amendment. Page 17. The heading of section 10 will be amended from withdrawal of notice of fixed penalty into demand notices. And in the subsections, we are also changing the wording to demand notices. Page 18, we are amending section 11 subsections 1 and 2. Concerning the parts and notice under section 8 bracket 3 will be amended into demand notice. There is already an interpretation for demand notice. Page 19, again we are changing the relevant wording into demand notice. Please carry on. Page 20, for section 15, we propose amending the original subsection A into a copy of the demand notice together with a certificate of posting under section 8 bracket 8. There are no questions from members. Please carry on. Page 21, we propose an amendment under section 18. The relevant wording in subsection 1 will be changed into demand notice. Page 22, for section 19, we are changing the wording under subsection C into demand notice. Page 23, we propose introducing a new section 23 after section 22. Transitional provisions for Housing Amendment Ordinance 2025. If a notice in Form 1 in Schedule 3 of the pre-amended bylaw has been delivered or fixed on a vehicle under Section 8 bracket 2 of the pre-amended bylaw before the amendment date, and if this section, then the pre-amended bylaw applies to the notice. Also, there are few interpretations. They include the interpretations for amendment date, amendment ordinance, and pre-amended bylaw. Page 24 to page 42, they cover the deletion of Form 1 and Form 2. So we're repealing the forms from page 24 to page 42. Page 43, 44, 45, 46, and 47. The forms are all set out in these pages, and those forms do not include any amendments. We're very close to the end of the meeting. Let me extend the meeting by at most 15 minutes so that you can finish the clause by clause. Page 49 of the Chinese copy, Schedule 4. There are two parts, Part 1 and Part 2. Part 1, fixed penalty notices. It sets out all the information that must be contained in the fixed penalty notices. They include the notice number, the registration mark of the motor vehicle concerned, and the alleged contravention. The amount of the penalty will be included in the notice as well. There will also be information about the period for making the payment and the payment methods as well.
Any questions? If not, then the next meeting we will wait for the public submission from the public, and then we will have the administration's reply to our questions. We have set aside the time slot from 9:30 a.m. to 12:30 p.m. on the 12th of May, 3 hours meeting, to allow sufficient time for the government to reply to members and the public's questions. Again, 12th of May, 9:30 to 12:30. I will notify the other members as well. Now, if some members have clashes of schedule, they can submit their opinions in written form. I believe the government will consider their suggestions seriously. That concludes today's meeting. Thank you.